Hi, everyone. I'm Kirk Schroder with the law firm of Schroder Brooks, and you are now listening to Brief Encounters. And today I am very excited because I get to talk to a longtime friend of mine who goes back to my early days as an entertainment lawyer when she was working out of the SAG-AFTRA office in Bethesda, Maryland. And that is Jane Love. And Jane is the National Director of Audiobooks for SAG-AFTRA. And so, Jane, welcome. It's good to see you. We're actually seeing each other, even though this is an audio broadcast. Hi, Jane.
Hi, Kirk. Thank you for having me.
Jane has a long history with the Screen Actors Guild. And Jane, just for some of our lawyers in the audience, can you just give a quick overview of what the Screen Actors Guild and AFTRA, combined SAG-AFTRA, does, what its role with respect to representing talent?
Absolutely. So it's the merger of, as you said, of the Screen Actors Guild and the American Federation of Television and Radio Artists. That occurred in 2012. So I was employed prior by AFTRA, and our office was paid a retainer to administer the SAG contracts. The union is the collective bargaining agent for anybody really behind a microphone or in front of a camera. So actor performers, broadcasters, sound recording artists, and everything in between that fall into those categories like stunt performers, background actors, and in my case, audiobook narrators.
So in the early days when you and I interacted a lot of my clients were signatories as producers, film or TV producers, to the SAG-AFTRA collective bargaining agreement. So let's talk about audiobooks now. Who are the signatories in the audiobook world?
Sure. And I should add, I just said collective bargaining agent, but of course that means we negotiate minimum terms and conditions of employment. And those companies, like you said, your clients would sign on to, in your case, the codified basic agreement around theatrical motion pictures or television, for example. And those contracts are quite mature and
well-developed.
Very well developed. And the union, of course, is there to, administer and enforce those contracts and to organize new work. And so in audiobooks, it's a relatively new area of union density. It's been the fastest growing area in SAG-AFTRA's jurisdiction for the last several years. Our signatory relationships are with everybody from Audible directly for the content that they produce. And I should say we expanded the scope of that agreement a number of years ago to include all of their Audible original content as well as audiobooks. We have contracts with Tantor Media, with Blackstone Audio, with Recorded Books. We have contracts with publishers, the people who actually license and publish the content. We also have contracts with outside producers, production companies to whom HarperCollins, for example, might subcontract out the work. And we have all told, I believe it's 87 different term signatory contracts. And we also do hundreds of what we call one production only agreements per year, often directly with indie authors who are self-publishing, which is a real growing area.
Well, and you answered two questions already a step ahead of me. One is that your contract sets out really the minimum expectations when someone hires voiceover talent that's covered under the union agreement. And then secondly, I just wanted to get a sense for our audience before we get into some of the issues, what the coverage is. It sounds like the majority of the major publishers, which I think is like down to 4 publishers because the Simon Schuster didn't do the antitrust case, didn't go through. But the major publishers, their affiliates, as well as some indies, it sounds like SAG covers most of that market along with the Audible market. What's the coverage?
The density is very, very wide. We do not have direct contracts with the big 4 or 5, however you want to define it, print publishers, but they hire our members through audiobook signatory paymasters. And we have a direct agreement with them that we can arbitrate around reuse in other media and synthetic voice creation, actually.
Wow.
So that's been a big push of ours for the last year.
I'm going to ask about AI and intelligence in just a little bit, but just for our audience, though, the key is voiceover work is very specialized. It's not just anyone can walk in and do that work. And there are talent. Do you call them talent? I don't know if you call them actors. How do you refer?
Generally, in audiobooks, they refer to themselves as narrators, but I think the
Okay.
preferred term outside of that would be performer.
And so there are very high end, sought after performers that are members of the union. And so one of the leverage that the union has is if someone wants to hire a performer that's in demand with respect to voiceover work and they're a member of the union, then that performer is not going to do the work unless they are under the union contract. And that usually is what brings the indies to the table and certainly the majors to the table and where you work.
That's right. And I will say, Kirk, we really only began organizing in this space in earnest in 2008. So we did have members, embedded in certain places and it was frankly critical to our organizing,
Uh-huh.
if that makes any sense. We
Yeah.
really just didn't have, we covered the work under the Sound Recordings Code, which frankly didn't really work for the industry. And I'll give you a major example. Audiobook work is very difficult, as you can imagine. Narrating a 10-hour book, single narration, where you are responsible for all of the voices, et cetera, is extremely hard. But the industry pays on a finished hour of recording basis, not a studio hour basis, unless you're talking about a genuine multicast production.
Wow.
And so the union we had to sort of adapt to that. And the narrators are generally all fine with that. That's how they've worked, sort of forever. And the industry's argument, of course, is that they don't necessarily want to pay more for someone who reads more slowly. The other thing is that a lot of this work is home studio based. The vast majority is home studio based now. Post pandemic, I would say that's even, during the pandemic, that even exploded more. And so there's really no way to track, that somebody recorded from an employer's perspective, right? That they recorded for 5 hours or something to end up. So it's a per finished hour basis.
So, like in the film or TV world, you have minimums with respect to how many hours worked, lunch breaks, travel, per diem, expenses, all sorts of things. What kind of unique minimums or what you would consider bottom line expectations the union agreements would ask of a publisher or producer in an audiobook performer world?
Generally speaking, so you'd have a minimum scale per finished hour of recording. So if it's an 8-hour book, those 8 hours.
What is minimum right now?
Well, it varies. And I'm actually going to, I think, refrain from comment on that if I
Okay.
may, because the 87 agreements are, in fact, a little different. I can give you some ranges.
Yeah.
If you're talking about an indie author who's self-publishing and the talent is just doing narration, they're not responsible for any sort of post-production work, proofing, editing, or mastering, our rock bottom minimum is $195 per finished hour plus the contribution to the SAG-AFTRA health and after retirement plans, which is running around 13.5% to 14. But, for example, one of the larger publishers, their minimums are running generally like 250 to 275 per finished hour plus the contribution.
So, like in the film and TV world where you have certain contracts based on budget, does that work the same way in the audiobook world?
We don't actually base it on budget. We generally, it would be, again, the indie author self-publishing thing is really, it's taking off. It's a unique situation, but it's not really budget based. We just don't really have the ability to monitor that. If you consider the fact that some of these publishers are producing, anywhere from 4,000 to 7,000 books a year, that's sort of not doable. So it's all subject to collective bargaining. Again, I don't want to call anybody out, but when we organized a fairly large audio only publisher back in like 2011, our minimum scale was somewhere around 165 per finished hour. And that contract now is well up to, 220, 225 per finished hour plus the contribution. So we've come a long way. We've generally gotten increases every year across our contracts, which we're proud of. But there are some other unique things. That's what you asked about, like rest period, per diem. Things that matter to narrators are things like how are our corrections, how are our mistakes delivered to us? When they make a mistake and the editor finds it, they want an audio file to be able to remind them, what they sounded like in that moment so that they're not, hunting and pecking through, hours of narration. They want them all lined up on a spreadsheet. They want, marked manuscript pages. And so we've been able to achieve the language in our agreements. And in some cases, that's been economic because the editors, hadn't heretofore provided sound files, for example, or things like payment for excessive research. If it's a very difficult book, sort of an abstruse title, they want to be paid for looking up all the pronunciations. Or conversely, we can get companies sometimes to actually agree in the agreement that they will provide the research, pronunciation guides, character descriptions, that sort of thing. Lately, of emphasis has been there's a big trend toward dual narrations, particularly in the romance genre. And if you think about it, Kirk, if you have to kind of collaborate with someone else, but it's a per finished hour of recording
Oh, wow.
Payment, you'll sometimes get paid less, right? And you still have to read the whole book. You have to prep, your parts. You have to make sure that the other person is on the same page because you don't want to find that one narrator is doing an Australian accent and the other one isn't for the same character. And so we've been looking at ways to reward performers, for that additional work as well. And the industry's been pretty receptive to it. Those are just examples.
Well, I asked because I know starting out as an entertainment attorney, especially in the film and TV side, if you don't know the film and TV process, you can't really represent your client very well. And this is a whole different process. And there are the things that are of concern that SAG-AFTRA may deal in these other areas of the entertainment world are not what this is. So what are the big things that you find, I don't know if the word is get violated or you need to make sure are enforced, and how do you monitor?
Yeah, that's interesting. I would say that the number one grievance situation, and I put that in air quotes for those of you who can't see me, because we have a very good relationship with the industry. I mean, I will say, we go to the Audio Publishers Association conference every year. One year, they were kind enough to ask me to present an Audie Award. The relationships are very collegial, so it's very rare that we have to file a formal grievance.
It's a little different than maybe the film and TV world, I'm just going to say.
A lot different.
Our audience, Jane's eyes just popped open when I said that. So,
but I will say that I think the number one thing is actually timely payment. We'll have payment deadlines, obviously, as part of our agreement that people should be paid, let's say it's within 15 days of completion of recording, including the corrections, or 30 days from delivery of the raw audio, whichever is later, so that the editor doesn't have sort of an open-ended, period of time in which to get the corrections back to the narrator. That's annoying to them too, because they've moved on to another project and they've sort of forgotten, that performance. So I would say we have real difficulty with timely payment with certain companies, not across the board. And frankly, the remedy for that, of course, is to bargain liquidated damages for late payment, which we have managed to do in quite a number of agreements as well.
Which certainly is an incentive to pay on time. So in the film and TV world, there are actors who want to get qualified to get in the union. If you're an extra for so many times, or if you say a word on screen, even if you end up on the editing floor, you can qualify for union membership. How does that work with the performers in the audiobook world?
That's right. And it's a good question. So eligibility for SAG-AFTRA across SAG-AFTRA's jurisdiction is, you either have to have had, one, what we call a principal job, by and large, a speaking part, although commercials works differently, or 3 days of union covered background work. Or of course, in the case of our news and entertainment broadcasters, you have a staff position, either, part-time, full-time at a union shop. So audiobook work, for obvious reasons, is considered a principal job, right? You have a very important and large speaking part. So one union-covered audiobook can make you eligible to join.
So now on the flip side of that, what would qualify someone to be an independent, get the independent contract? Let's say if I come to you and say, Jane, I've got so-and-so and they want to produce an audiobook, what would it take for them to get the independent agreement versus the Audible agreement, or how does that work?
Oh yeah, every agreement is different. So if you were coming to me to sign on for a term, a period of time, in other words, you're going to agree to cover all the audiobooks that you produce from January 1, 23 to, December 31st, 26, for example, we would start by talking to you about what your business is, who are your clients. If you're a producer and you're primarily producing for, you used Simon & Schuster as an example, there are established rates It's been very important to us to make sure that all of our producer partners are on a level playing field because they're all competing for work in that same space. So those terms, those rates are much more nailed down than, for instance, we bargain with Audible over, all of their contract, or for instance, Blackstone Audio out of Ashland, Oregon. That's, where we're dealing directly with the publisher. They're going to agree to cover all of their books, under union terms and conditions. Those rates vary more than, for instance, if Kirk Schroder Productions said, well, I work with, Hachette, Simon & Schuster, Harper, and whoever else. We would have rates really prescribed for that scenario.
Okay. I guess then the big thing is, where do you see the industry going in terms of just technology? I mean, you touched a little bit on it. I was dealing with one of your legal colleagues not long ago about fake videos and all the different things. Yeah, deep fakes and all that. How does that affect the audiobook world, or what are the sort of things that AI and other technologies have that concern you or that the union is paying attention to?
Yeah, we're paying very close attention. I did mention earlier that we're really proud of the work that we've done to ensure that if companies do want to engage in synthetic voice creation, utilizing, our members' voices, that they would need to bargain with us about that. And we have had lots of conversations with industry around that. So far, I am not aware of any of our partners doing that. But, and I don't want to say a whole lot, but we are ready to bargain a fair agreement around that, as long as there are certain pillars, of course, right? Like, safe storage of the voice, a reasonable term.
I'm interrupting you here, but just so our audience can understand, we're talking about taking someone's voice and recreating it over for other circumstances. Is that correct?
Yeah, we're talking about, a synthetic version of either that performer's voice, which is one thing, right? Or even an amalgamation, of several voices to create a whole new one.
And the person getting paid is the originator of that voice, if that's the right term.
Right. I mean, we're not there yet. We do not have any company that has said to us, we want to go here and let's make a deal. We have had in my world, the narrators are not household names to your audience, but in my world, high profile, we've had narrators be approached about, would you be willing to, let us data mine your voice and this and that. And nothing has ever come of it, even though we've gotten pretty far down the line in discussions, largely because the person has just decided, you know what, my brand is too important and I'm not ready to go there yet. But that is a huge concern and tension, frankly, between the narrator community and the industry, is this notion, of replacing the human performance with, avatars, and how that will be monetized if companies do actually ultimately go there.
Okay. I think you may have covered this point before, but I just want to be clear. There's no back end. There's no net profit or royalties in the audiobook world, or do you see that, or does the union have any interest in achieving that?
By and large, there is not. There are some. This may open up a whole Pandora's box we don't want to go down, but Audible's ACX, the Audible Audiobook Creation Exchange, there are opportunities for union-covered work that involve royalties through that platform. We have one additional agreement that includes some additional compensation when the digital downloads exceed a certain number. I would say that we are working toward that, but the narrators are a very intelligent group. And I have to say that it's not clear that most audiobooks actually make a lot of money. And so while this does not represent the views of every single person I represent, there is a pretty healthy group of narrators who thinks it's much more important to focus on continuing to increase upfront payments, strengthening the health and retirement contribution, which matters in terms of your own personal retirement, and continuing to grow and make our contracts more mature and including, provisions that are sort of typical of SAG-AFTRA. there has not been a real emphasis on residuals or shared royalty in this space.
And just in our closing 3 or 4 minutes, what advice do you have for attorneys in this area that are representing either publishers or because for the most part, the narrators are covered under the union agreement, and that's important for anyone representing a narrator. But what do you recommend for attorneys representing independents or just new to this area where they can act with knowledge and effectiveness in dealing with this? Any suggestions or advice?
That's a tough one. If we're talking about a publisher that already has a collective bargaining relationship with us.
I think maybe the indie world, someone new or in that world.
Okay. I do want to be clear about what I mean when I say indie. Yes, we have small press, small publishers with whom we have relationships for sure. I think that I would say that we would be happy to have a conversation with that attorney. I am even, willing to share sort of a template document. What is harder for me to nail down is exactly what the appropriate minimum might be. We define small press as any company that is producing fewer than 50 audiobooks per year. Then that's really, like I said, we could generally go as low as 195 or so with some bells and whistles around, dual narration. And certainly if something truly is a multicast book, Kirk, where everybody's connected via, Source Connect now, then it is a per studio hour rate, right? You're booking somebody from 12 to 4. They have to be there regardless of how long their part is. And so those rates are pretty static. But otherwise, it truly is a bargaining relationship. It has taken us a long time to hammer out some of these things with those companies.
Yeah, and I think the point you're saying indirectly is the attorney just needs to do their homework and understand the process and understand what's important and what's not, and come to you with some level of knowledge where you're not having to explain things that are just really non-starters in a situation. And that happens, I imagine, in the union world. In fact, I've seen it. You and I both have seen it on many occasions. So.
Yeah, I think you're right. I think that some of the things, one big non-starter, and it's a conversation I have to have every single time with these companies is, no, our agreement is not going to just cover members of the union. It's going to cover anybody who is recording this work. That's how people get eligible to join for one reason. That is something that has taken people in the industry a long time to really grasp.
Great. Jane, we could talk about this much longer, but we are restricted with the time of the podcast. But it's always good to see you, and I thank you for doing this today. And wish our audience, I guess, anytime that they have a question, they can always reach out to the union.
I'm here, Jane, Jane.love, Love, at SAG-AFTRA.org. It's on the website. Under contracts, under audiobooks is my personal email as opposed to, a department email. It's a small department. There are 3 of us. And any one of us is delighted to talk to your folks.
All right, then. So you've been listening to A Brief Encounter, sponsored by the DC Bar. This is Kirk Schroder with the law firm of Schroder Brooks. And we've been happy to have Jane Love, the National Director of Audiobooks for SAG-AFTRA. Thanking everyone for listening and hoping that you got some good information from this podcast.